Paul Jackson.
Yes, ma'am.
And this is cause number 26 DCCR 0112. Mr. Jackson was previously in court, entered a plea of guilty to aggravated robbery. There was no agreement in this case. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
Stay as judge.
Are there any additions or corrections?
Not from the defense.
Not from the state judge.
All right, Mr. Rojas, you may proceed.
Thank you, Your Honor. I realize, Judge, we've got a problem with guns in this county, and more specifically in the city. I don't know that anything we do here today is going to solve that problem. Certainly, there are things you can do to deter other people watching this and see what happens to young people with guns. But I think there are some people who are not going to learn their lesson until they go to prison and spend a certain amount of time there. There are some people who are going to go to prison and never going to learn that lesson. They'll just spend their life in a revolving door, coming into court, prison, in court, back to prison. And there are those that, for whatever reason, the circumstances they find themselves in their life, they make bad decisions, make mistakes, and are deserving of a second chance. And I think that's the category we find Paul in this morning, Judge. I think if you look at the letters that were written on his behalf, he was raised by his mother and his grandmother. He lost his mother. I think he was 15 when she passed away. His life went into a downward spiral from there. Just lost hope. Didn't see any reason for continuing on. Got involved with some bad people, and made some bad decisions. But I don't think that those decisions or what he's done in his life on that one day are irreversible. I don't think that's something that should cause him to go to prison for a certain amount of time and have a felony conviction on his record and come out possibly worse than he is today. As far as the incident reports, all the incident reports that are negative happened prior to the plea. I think there's an incident report that happened recently I think he hurt his knee or something else.
Yeah.
That's nothing bad against him, I don't believe. He's a 17-year-old kid. If he's allowed to be out on probation, he's going to go back and live with his grandmother. He's got a good support system. You can see from the letters. He's got family that'll help him out. I don't know that. I think if you're going to give him probation, I think probably ISF would be a good condition of probation. As I said, he's 17. I don't think he can go to ISF until he's 18. He doesn't turn 18 until July, so I would assume still be in jail until his birthday, and then the bed frees up in ISF. So he's not going straight to the street right now if you were to send him to ISF. I've spoken with Paul. Every time I speak with him, he's kind, respectful. I just really think this is a kid who made a bad decision on that one day, and I don't want that to ruin his life. Speaking with him, he is remorseful. He's sorry this happened. He asks about the two kids, the victims of the case, and he wants to issue apologies to them, and hopefully they're not too traumatized by what happened. But again, Judge, he's just asking for a chance, and I really think he deserves a chance. This is a kid that doesn't need to go to prison. If you look at his life before his mom passed away, apparently he was doing good in school. Once mom passed away, he started missing school and had to go to a different education place, and so he just had a traumatic event in his life, and his life took 180-degree turn from there. But I think it's something that can be reversed, and he's just hoping that you give him a chance to do that.
All right, thank you.
Your Honor, you know where I stand on these kind of cases, so I won't belabor that. But what I will do is point out what I consider to be aggravating factors in this case, Judge. And despite Mr. Rojas's argument as to what mitigation there is in this case, I believe the aggravating circumstances outweigh any mitigating circumstances. And what I'm getting at is the fact that this defendant robbed at gunpoint with another co-defendant who was also brandishing a firearm, a 16-year-old, took his iPhone in front of that 16-year-old's 5-year-old niece, Judge. Can you imagine the trauma to that 5-year-old to watch her 16-year-old uncle get robbed at gunpoint, Judge? And with regard to the firearm that this defendant used, it was a P80, Your Honor, for the courts, in case you're not familiar with that, polymer 80 firearm that comes in a firearm kit that is partially complete. Doesn't take much to make it a functioning firearm. The thing about that is the ATF calls those guns ghost guns because they have no serial number. I submit to the court, what does a defendant, in this case, a 17, at the time, a 17-year-old defendant need with a firearm that does not have a serial number, Judge? So for those reasons, I say that any mitigating circumstances are outweighed by those aggravating circumstances that I just referenced. And I'd ask the court to sentence this defendant in accordance with your sentences in other similarly situated cases, Judge. Thank you.
Thank you, Mr. Coleman. Mr. Jackson, these cases are hard for me, and I know Mr. Rojas has told you what's been going on and what's been going on in this court, and I'm sure you're aware of all of that. I find your case a little bit different than some, but not the guns are the biggest concern for me and for everyone. And the using them in a way like it's no big deal and everybody having them at 15, 16, 14, whatever. I appreciate the fact also, though, that you've never been in trouble. As a juvenile, you've never been in our system. You figured out real quick that you need to follow the rules in jail, because I'm sure word got out there people are talking about the fact that that is something that really affects me and what I do. And so I appreciate the fact that you've gotten your act together out there. And I'm talking because I don't know what I'm going to do with you right now, because I don't disagree with either attorney here today. And that puts me in a position where I've got my job is two things. Is one well, more than that, really. One is to protect our community. Another is to punish. Another is to rehabilitate. It's something where I have to potentially take chances that makes me sometimes uncomfortable. It looks like that before your mom passed away, you were doing really well in school, playing basketball, right? And that's a hard thing to go through, especially at your age. But you can't let something like that get you where you are now, right? What would she want you to be doing? Not this, right? So does grandmother live in the same neighborhood where all this took place? You live with your grandmother, but does she live in that same neighborhood? Is that where you were living when this happened?
Not literally by the neighborhood. Some like
How far away from those apartments do you live?
2 blocks.
Do you have anything you want to tell me?
Apologize to the victim and the victim family for putting them in this situation.
All right, here's what I'm going to do, Mr. Jackson, and I hope that you don't make me regret this, because here's what's going to happen. I'm going to give you a probation. There's going to be all kinds of conditions on this probation. And because there was no agreement, the type of probation that I'm going to give you means that if you violate it, I'm going to have the entire punishment range, which is between 5 years and up to the rest of your life. You understand that punishment range? I can tell you this today, if I had sent you to prison, probably would have been in the 15, 20-year range. If you're back in here after I give you this opportunity, it's not going to be that. I can't tell you what it'll be. I don't know. It'll depend on what all's going on. But if you go out there and make me look like a fool for giving you an opportunity, it's not going to go well. You understand that?
Yes.
I want you to succeed. You've got family here. They want you to succeed. So what I'm going to do is find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to defer all proceedings. You will be on probation, on a deferred probation for 10 years.
Yes.
I'm going to order a $500 fine. I'm also going to order that you serve 3 months upfront time. And so after that 3 months in our county jail, you will then be ordered to enter and successfully complete the cognitive track of the ISF program. And let me tell you what that program's for. It is to help you make better decisions. You need to pay attention there. You're still young and your life is going to be very different. You're not going to be able to do everything that your buddies are doing. You're going to have to follow these rules because if you don't follow the rules, you're going to go to prison. They may or may not. So you're starting off your early adulthood very different, and you either make a conscious decision to change and grow up and be mature about it, or you end up in prison. It's that simple, right? Once you get out of ISF, you'll live with grandmother. I'm going to order that you are ordered to live with her at her house until I order otherwise. So you get a job, you want to get your own place, you want to go live somewhere else. You don't get to do that without my permission. So you don't get to go hang out other places. You're home every single night. You will have a curfew. If you're not there and you're caught not home when you're supposed to be, you're right back in here and you could go to prison. So I'll do what I can to put the rules there. It's up to you to follow them. Make sense? Obviously, a condition of your probation is that you are not allowed to have any firearm at all. You cannot have firearms at your disposal. So if there are firearms at grandmother's house, they either have to be under lock and key or removed from that house. I can assure you, if you get in trouble with a gun again, it's really not going to be good. Okay. This is your chance. I hope you take it and this changes your life, because this type of probation that I just gave you means you do not have a felony conviction on your record. So if you have a felony conviction, it changes your life really bad in a lot of ways. You can't get certain jobs, you can't go to certain schools, you can't live certain places, even apartments. Sometimes they don't let convicted felons live there. So you don't have a felony conviction right now. But if you violate, you're back in and you do. So you kind of have a clean slate. It's up to you to keep it that way. Okay. I'm handing you the trial court certification that shows this was an agreement. Or there was no agreement. Actually, you do have some rights to appeal. You can talk to Mr. Rojas about that.
Judge, I would ask that the court consider making a condition of his probation, no contact with the co-defendants.
Yes.
And I was looking for the names of those co-defendants. I can't find this.
It might be in here. So, Mr. Jackson, you are to have absolutely no contact, no communication whatsoever with Dale McDonald. Okay. And also obviously no contact, no communication with the victims in the offense. You're not to go near that street or their house. So if that's the way you normally get in and out of the neighborhood, you've got to find another way to go. You cannot be anywhere near that area. Do you understand?
Yes.
Okay.
Judge, there was a third subject who was, or co-defendant who was unidentified at the time of the offense. I think that in Mr. McDonald's case, there was at least an identification made, information as to that third individual. I don't have that in front of me.
So whoever the third guy was, and we'll get their name, you can't be around him as well. And that doesn't mean just in person, like y'all can't send each other messages on DMs or anything like that. You understand?
Yes.
Okay. All right. Go back with the bailiff.
Thank you, Judge.
Good luck to you, sir.
You just,
I've got the first two. Oh, you did? Mm-hmm. Did you already do it?
There's two F-19s and an F-20.
Hey, ma'am, are you Ebony Broussard?
Yes, ma'am.
And will your client, it's my understanding she's going to just enter pleas unagreed on the motions.
Request to bond her escrow.
Raise your right hand the best you can, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can put your hand down. Will your client waive the formal reading of the motion in each of the cases?
By formal reading.
Ms. Broussard, in cause number 19-32518, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 21st of 2020 for the third-degree felony offense of escape while arrested And that was a 10-year deferred probation. Is that correct?
Yes, ma'am, it is.
And then in cause number 19-32806, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 21st of 2020 for assault on a peace officer, a second-degree felony. That was also a 10-year deferred probation. Is that correct?
Yes, ma'am, it is.
And then in cause number 21-36615, also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 12th of 2021 for the state jail felony offense of possession of a controlled substance, and that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
Hold on. Each of these cases allege that you violated your probation. Count 1 in each case alleges that you committed the new offense of public intoxication, January 23rd of 2026. And is that true or not true?
Yes, ma'am, it is.
True.
Yes, ma'am.
Count 2 in each case alleges that you committed the offense of possession of a controlled substance, January 23rd of 2026. And is that true or not true?
Yes, ma'am, it is.
True.
Yes, ma'am.
Count 3 in each case alleges that you possessed an illegal drug, namely PCP, January 23rd of 2026. Is that true or not true?
Yes, ma'am.
True or not true?
Yes, ma'am, true.
Thank you. Count 4 alleges that you became intoxicated or was under the influence of an intoxicating substance on January 23rd, 2026. Is that true or not true?
Yes, ma'am, it is true.
And then finally, count 5 in each case alleges that you're behind in your court assessed fees. Is that true or not true?
No, ma'am, that's not true.
You're all caught up on your
Yes,
fees in
ma'am.
every single case?
Yes.
Is that date, Your Honor, or is it just?
So in cause number 19-32518, the allegation in count 5 is that as of February 2nd, 2026, you were $1,640 in arrears. Is that true or not true?
That was true in February, but I'm caught up on it.
Okay,
She said I was just $22 behind.
It's not right. It's not.
Oh, in February.
February, you were
Oh,
behind.
yes, ma'am, that was true in
Okay.
February.
In cause number 19-32806, count 5 alleges as of February 2nd, 2026, you're $965 behind. Is that true?
Yes, ma'am.
And then in cause number 21-36615, the allegation in count 5 is that as of February 2nd, 2026, you were $555 behind. Is that true?
Yes, ma'am, that was true.
Did you enter your,
Where?
and when we come back, we can get the actual amount and where she is with an updated report. Did you enter your pleas of true to counts 1 through 5 in each case freely and voluntarily?
Yes, ma'am, I did.
And did you plead true to all of those counts because they're actually true?
Yes, ma'am, I did.
All right, then in each of your cases, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily, find those counts true, find sufficient evidence to find you guilty in each case and revoke your probation. However, I'm going to order an updated report from the pre-sentence probation department, and then we will come back at a later date for sentencing. Obviously, anything that you think is important for me to know, get that information to Mr. Kimler and he'll present it to me on your behalf when we come back.
Yes, ma'am.
Yeah, right. Plus bonds, I know the court may be a bit reluctant to do that because of her conditions that she was under the influence of intoxicating substance, particularly PCP.
Already set bonds.
Oh, yeah.
There was a request and they were set in each case. I'm not going to modify those amounts. All right, we'll see you back at sentencing. Anything? Yes, ma'am.
Yes, just since,
Hang on just a second. Go ahead.
just because these officers have been here this morning, I would just like the opportunity to ask if they have anything with respect to Ms. Broussard. I know Ms. Richard as a supervisor is here and has diligent notes on it. If there's anything that they feel is important for the court to note at this point, or would you rather wait?
I would rather it be either in the update or come then because in 6 weeks, I'll probably have forgotten what we talked about.
No, that's fine.
I appreciate y'all being here. I'm sorry this one ended up last, but yeah, let's just get an updated report, get everything you need in there. And then if there's any other testimony, we'll get that at those sentencing.
Yes, ma'am.
Thank y'all for being here.
May I just ask, in the instance that she were to make those bonds, would there be anything that you all would recommend with respect to?
They're $100,000 in each case. There's a GPS and a drug patch already ordered. Anything else that y'all would want? I figured that would cover it.
Yeah.
All right, thank you. You can go back with the bailiff.
Yes, ma'am.
Oh, I'm sorry, she needs your thumb. Good morning. Are you Jaden Worlds? And Mr. Parker, will your client waive the formal reading of the indictments and the motions in each case? Mr. Wilton, cause number 26, DCCR 0361, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon from January 21st of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? Give me just a second. And then in cause number 26, DCCR 0415, too many buttons. You're charged with a first-degree felony offense of aggravated robbery, and that's from January 27th of 2026. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In each of these cases, those two cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal? Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each of those cases.
Judge.
It's admitted in each case. Is there any evidence that Mr. World is not competent?
No, Your Honor.
All right, sir, in cause number 26, DCCR 0361, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Correction. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding in that case of a deadly weapon. In cause number 26, DCCR 0415, also find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you in accordance with that agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm also making an affirmative finding in that case of a deadly weapon. Now, in cause number 24, DCCR 1721, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation October 8th of 2024 for the state bill felony offense of unauthorized use of a motor vehicle, and that was a 5-year deferred probation. Is that correct?
Yes.
And then in cause number 24, DCCR 1420.
This is a defining moment of the hearing because a judge is taking an enormous legal and personal risk by choosing rehabilitation over immediate prison time under Texas law. Deferred probation is incredibly significant because it allows a defendant to avoid a permanent felony conviction if every condition is successfully completed. But the consequences for violating that probation are severe, especially in a first-degree aggravated robbery case involving firearms. The judge openly warns that if this defendant returns to court after being given this opportunity, the punishment could become dramatically harsher than what was originally on the table today. Emotionally, you can hear how much weight the court is placing on the defendant's age, family support system, and the belief that grief and immaturity may have contributed to these decisions rather than permanent.
1420 will also have a motion to revoke your unadjudicated probation. This shows you were placed on probation October 8th of 2024 for evading arrest or detention with a motor vehicle, a 3rd-degree felony. That was also a 5-year deferred probation. Is that also correct?
Yes.
Each of these cases allege that you have violated your probations. Count 1 in each case alleges that you committed that new offense of aggravated assault with a deadly weapon January 21st of 2026, the one that we just went through. And is that true or not true?
True.
Judge, to save time, lead to count 5 and count 7 in both of those motions. And it'll be abandoned the rest if it's
They're
sufficient.
different. The motions are different. I'm not sure if that matters.
But those are the same counts.
There's not a,
Same allegations.
there's not a count 7 in 1721.
1420, there's a count 7 and
Correct.
count 5 in the other one, and it's the same as count 7.
So 5 in one case, 7 in the other.
Yes, Judge.
So in cause number 24 DCCR 1721, it also alleges in count 5 that you possessed and used a firearm, namely a handgun, to fire shots at 2 people on January 21st of 2026. And is that true or not true?
True.
And then in cause number 24 DCCR 1420, count 7, in that case also alleges that same violation of firing the handgun. Is that true or not true?
True.
All right, so did you enter your pleas of true to counts 1 and 7 in 1420 and 1 and 5 in 1721 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true? I have also here on the tablet some documents in those 2 cases that have your signature on them that the state's marked as Exhibit 1. Did you also go over these with Mr. Parker? And do you understand them as well? And you also understand if I follow these agreements, you'll be waiving or giving up any right to appeal. State tenders number 1 in each of those cases.
Objection.
It's admitted. All right, Mr. Worlds, in cause number 24 DCCR 1721. Find that you entered those pleas to counts 1 and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time finds you guilty of the state jail felony offense of unauthorized use of a motor vehicle. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24 DCCR 1. Hold on, I just pulled the wrong one up. I looked at the wrong thing. What's the agreement on?
2 years TDC and 2 years state jail.
Gotcha. So in cause number 24 DCCR 1420, also find that you entered your pleas of true freely and voluntarily. Find counts 1 and 7 true. Find sufficient evidence at this time to find you guilty and find you guilty of evading arrest or detention with a motor vehicle. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All 4 of these cases will run concurrently, which means together at the same time. In all of these cases, I'm going to hand you the trial court certifications that shows that these were agreements that I followed, and so you have waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Plucker. All right, good luck to you, sir. You can go back with the bailiff.
Here you go. Hey. All right.
So it's just in the third case, the new case.
And
Are there bonds in the motions?
She's on bond on the new case, the 22, May 22,000. She's in custody, she's waiting custody on the TRP. We're saying that it falls in the TRP, she's not bonded out. Okay. That the bond on the TRP is different.
What I said on that. I'm sorry.
25, 50, 25, 25.
Did I know that there was a robbery at
Yeah,
that time?
we were,
Yes,
we were
Judge.
just here.
You had actually indicated to me
Oh, that the robbery
that the
was
bond
low.
was low. Robbery
Yes.
At 22.
Yes, $22,000 on a robbery when you're on probation for 3 felony offenses seemed very low to me. And this is one of those things when we're trying to get it worked out where some of the magistrates, not some of them, depending on the case, they're unable to see if someone's on probation.
Mhm.
And we're trying to get that worked out because I think surely that was what happened on this one, because I know they wouldn't have done that. So.
I don't mind resetting the week.
Yeah, let's do that, Ms. Holmes, so that you have an opportunity to look at the motion, as far as that, the robbery, which is 25-1826, the motion to increase the bond in that one. We'll reset it 1 week and we'll come back next week on that motion.
Okay.
And then we can, figure out where we are with regard to an announcement as well, potentially.
Okay, has bonds been paid or?
She's on bond in the robbery,
Okay.
but she's not on bond in the motions. I set bond
Okay.
amounts because they were deferred,
Right,
but she has not made those bonds.
Okay.
So we will only be here on an increase request on the robbery.
okay,
Okay? So we'll just reset it 1 week.
okay.
Are you Francisco Garza?
Francisco Garza.
And this is 25 DCCR 1623. I'm going to take judicial notice of the court's file. Mr. Garza was examined by Dr. Capon for competency to stand trial. I've received that report dated April 21st of 2026. The finding in his report is that Mr. Garza is currently not competent to stand trial and that inpatient treatment for restoration of competency would be warranted at this time. Is there any other evidence with regard to competency?
No, Your Honor.
Okay.
All right, then at this time, I am going to find based on that report that Mr. Garza is not competent to stand trial. Order inpatient competency restoration treatment for a period of not to exceed 120 days from the date he gets to the appropriate facility, and then we will await a report from them at that time. You're going to go to a hospital so that they can get you where you can understand everything. Okay, Mr. Garza, you need to cooperate with them. All right, and then we'll get you back here to go through your case. Okay, you can go back with the bailiff. You're Alethea McDonald. Is that your name? And this is clause number 26 DCCR 0348. And Ms. McDonald was evaluated for competency to stand trial by Dr. Capon. I've received that report dated April 21st of 2026. The finding in his report is that Ms. McDonald is currently not competent to stand trial and inpatient treatment would be
By
required.
the end of this courtroom session, the judge delivered a powerful reminder that every criminal case carries consequences that extend far beyond a single hearing. Some defendants received rare opportunities at rehabilitation through deferred probation, treatment programs, strict supervision, curfews, and long-term monitoring designed to keep them from becoming repeat offenders. Others admitted to violating probation through drug use, public intoxication, or entirely new felony conduct, and now face sentencing that could permanently alter the course of their lives. The hearing also highlighted how quickly criminal behavior escalates, from unauthorized vehicle use and probation violations to
By
aggravated
Dr. Capon. I've received that report dated April 21st of 2026. The finding in his report is that Ms. McDonald is currently not competent to stand trial and inpatient treatment would be required for competency restoration. Is there any other evidence with regard to competency?
No, Your Honor.
Not from the state judge.
All right, then at this time, I'm going to find that Ms. McDonald is currently not competent to stand trial. Find that inpatient treatment is necessary for competency restoration and order her to the appropriate facility for a period of not to exceed 120 days from the date she gets to that facility for competency restoration. All right, you can go back with the bailiff. You can go to the back.